Good day, everyone. My name is Tamsyn. I am an admitted attorney of the Cape High Court and the fiduciary specialist here at Appleton. Today, I would like to discuss the different marital regimes that we have in South Africa and how they impact your will and estate. Matrimonial property regimes dictate how your assets are dealt with during your marriage and then upon death or divorce. In South Africa, we have three main matrimonial property systems, those being in community of property, out of community of property, and out of community of property with the accrual system. These regimes have significant implications for the drafting of your will, the distribution of your deceased estate, and the rights of your surviving spouse. Let's start with marriages in community of property. This is the default regime in South Africa should you not enter into an anti-nuptial contract before you get married. What this regime means is that all the assets and liabilities that you and your spouse had before the marriage and during the marriage are jointly owned. Moving on to marriages out of community of property, what these mean, it's quite the opposite of in, being that all the assets and liabilities acquired by each spouse before and during the marriage remain completely separate. What's theirs is theirs and what's yours is yours, with both assets and liabilities. So, when it comes to drafting your will, you have complete freedom to bequeath your estate however you'd like. But it is very important to remember that although you can leave your spouse out of your will, should you choose to, they can still bring a claim against your deceased estate in terms of the Maintenance of Surviving Spouses Act. Moving on to our third system. This is a marriage out of community of property with the accrual system. This is created in your antenuptial contract where you choose to incorporate the accrual system. This incorporates both elements of independence and shared wealth, in that whatever the two of you brought into your marriage still remains yours, but whatever grows during your marriage, i.e. the accrual, is shared upon death or divorce. So, under the accrual system, your surviving spouse will have a claim against your estate should there be accrual owing to them. This is an automatic right which they can bring directly to the executor, and they do not have to go through the Maintenance of Surviving Spouses Act. It is important to remember that an accrual claim takes precedence over the provisions in your will. That is why it is very important to keep an up-to-date accrual calculation during your marriage so that when you draft your will, you know what you can and cannot bequeath. According to Section 7, subsection 6 of the Recognition of Customary Marriages Act, a husband who wishes to enter into a further customary marriage or marriages has to apply to court for a contract that will govern their matrimonial property regime. This can also be in or out with accrual. It is often the case, however, that these steps are not followed. And in that case, the court came to answer the question, and the issue was settled in the matter of Ngwenyama versus Mayelane, where they said that should Section 7, subsection 6 not be followed, the automatic or default position of the further marriages will be out of community of property. So the initial marriage will be in, the subsequent marriages will be out. In conclusion, aligning your will with the legal requirements of your matrimonial property regime will reduce disputes among your heirs and beneficiaries. Whether you're married in community of property, out or out with accrual, understanding the legal implications is vital for effective estate planning. Should you wish to know more about this topic, You can contact Appleton at 0800 50 60 70 or email us at clientcare@appleton.com. Bye for now.